Welcome to the I Got Fired podcast for people who've been fired or afraid that they might be. I'm Tom Spiegel, the founder of the Spiegel Law Firm and host of this podcast. A little bit of legalese before we get started. This is intended for educational purposes. It's not intended to be legal advice to you. And you can guess what I'm going to say next. If you want specific legal advice to your case and have an attorney-client relationship, then you should go hire an attorney. So today, what we're going to be talking about, it's going to be a fairly short podcast, but I think it's an important point. A tactic for being able to afford legal services or to be able to find a lawyer that you want to work with. And the tactic is what I'm going to call put a pin in it. And that essentially is, when you can step away from the legal issue that you are facing to give yourself time to either collect your thoughts, collect your money, get to a better spot where you can really kind of engage in essentially a court battle or potential court battle with your former employer. And by put a pin in it, I mean that there in employment law, there are some times when you have to act very quickly. And it really depends on what the statute of limitations is or limitations period is for your claim. And I'm not going to get into that in this podcast. We'll maybe talk about that at a later date. We've got a lot of information about that on our website. But there are times when you may have as little as 15 days, particularly if you're a federal employee, to be able to take action. And in the private sector, it depends on what your claim is. And again, you probably will need to do some of your own research, talk to a lawyer to figure out what the limitations period is for your claim. But let's say, for instance, that we are talking about a federal law discrimination claim. And in order to bring that claim, a limitations period that you will have is depending on which state you're in. You either have 300 days or 180 days to file a charge with the EEOC, the Equal Employment Opportunity Commission. And if you fail to do that, it doesn't matter how strong your claim is, you lose your right to bring it forever, assuming that is your only claim. So the tactic is, or my point is, when you are, let's say, fired or you're being harassed at work, I mean, obviously these are very traumatic experiences, one that understandably people want to take action right now. And look, all things being equal, it's better to act if you're going to hire counsel and send a demand letter and start the litigation process. It's better to start that sooner rather than later. However, there's nothing, it's probably not going to substantially affect your case if, let's say, that you do have, this federal cause of action, and let's say you're in a state with a shorter statute of limitations and you've got 180 days. It's probably not going to hurt your case if you have to wait 90 days in order to do something. So if you are, this has just happened to you, let's say you've just gotten fired, you're pretty sure it's wrongful termination, but you've got a lot going on. It is an emotionally difficult time for you. It's a financially difficult time for you. There may be you got to look for a new job, other changes that you might need to make that will make it certainly not impossible, but difficult to hire, either find and or hire a lawyer right off the bat. And I think a lot of people understandably are a bit confused by that and feel like it's either now or never. I've got to find this lawyer and pay for him or her right now, or I'm just walking away from this. And I think an alternative way to look at that is, if you have the time, give yourself some space. Give yourself a couple of weeks, give yourself a month to focus on the things that you need to focus on right now. Getting your resume together, reaching out to your contacts, looking for another place to land, maybe seeing a therapist or whatever you need to do to put yourself back together, kind of heal from this trauma, and then come back and revisit the issue. And if it is a matter of finances, and sometimes it is for a lot of people, like unless you're going to find a lawyer to take your case on contingency, which is possible. We just did a whole series on how to get a lawyer to take your case on contingency, but even that can take some time. First, to find a lawyer who's willing to take your case on that basis, and to get that lawyer all the information that he or she needs, that can be a little bit laborious. So I just noticed my shirt and tie sitting in the background there. But that can take some time. So understand that if you've got a few months, and sometimes you'll have more than that, take it if you need it. If you're talking to lawyers, right off the bat, which I think is a good thing to do, certainly to talk to a lawyer to understand what your claims are and what the limitations period is, because that can be sometimes a little bit difficult to figure out. So it's worth, I think, talking to a lawyer. There are a bunch of different resources, but certainly if you have to pay for an hour of a lawyer's time to get a sense of what are your possible, what we call causes of action, and what's the deadline for bringing them. Because depending on the cause of action, some of them, it could be a number of years before you have to bring it. Again, not ideal, because you want the evidence to be as fresh as possible when you bring the claim. And obviously, if it's 4 years later, people are going to move on. Managers change. It can be sometimes difficult to go back and piece things together. But that said, these cases happen all the time. We bring cases, that can be years old and successfully. So understand that if it's a matter of finding an attorney or getting the finances together, to understand what time you have. And use it. If you've got, let's say, a year before you have to bring your claim, and let's say right now you've just been fired, you don't have an income stream, things are uncertain as you're looking for a new job or making other changes in your life, and let's say you can't find a lawyer, your kind of case is not one the lawyer's going to take on contingency, so you're going to have to pay for your fees, and that's something that is important to you, then take that time, find another job, get that income stream coming in, because you may be in a completely different place 6 months from now than you are right now, than you are right at the point at which you experienced the wrongdoing. And you may be in a much stronger point, both emotionally and financially, at that point to be able to make a decision about whether you're going to pursue legal action, what kind of lawyer you're going to hire, and be able to finance that kind of litigation. So my recommendation is right after you've been fired or when this has happened, yes, do your research. There's a lot of it there on our website. We've got podcasts, we've got videos, and of course, Chat GTP and all these resources for you to get your own sense of, what kind of limitations period you are looking at. You can even go to avvo.com, avvo.com, and it's been a while since I've been on the site, but I believe they have a service where you can pay a reasonable, relatively small amount of money to get a consult with a lawyer. There are other resources. For example, if you're in Virginia, there's the Fairfax County Bar Association. They have a lawyer locator function. Well, they'll actually pair you with a lawyer for an initial consultation. Again, there is a dollar amount, but it's pretty reasonable. To be able to talk to somebody and say, hey, this is what happened. I'm just trying to figure out, what my limitations period is, what my limitations period is. And you may have multiple. That's why it's helpful to talk to a lawyer. You may have, a number of different claims, some of them that, that may require filing at the EEOC. And so you either have 180 or 300 days, and some that may be longer than that. So you may have multiple different deadlines. And again, talk to the lawyer. It could be, for instance, if you have, let's say, a race discrimination claim, there are two different causes of action. There's one under Title VII, which is the big federal anti-discrimination law. And that does require that you file with the EEOC. There's also something called a Section 1981 claim. That is, you can also use for race discrimination claims, and it has usually depends on the state, but up to a 4-year statute of limitations, and it's the same damages. Like, you're not going to get, and in fact, the Section 1981 claim, you have better damages because there's no cap on what you can be awarded, which exists in a Title VII claim. So that's a situation where, yes, in order to bring the Title VII claim, let's say you're in a state where you have a shorter deadline, you have to file it within 180 days. that's you're going to have to decide, you may want to do that on your own to protect the statute. Any number of ways you can do that, and talking to a lawyer can help you kind of develop a game plan. But let's say, for whatever reason, you're not going to be able to meet that deadline. And so the 180 days or the 300 days passes. And so you're not going to be able to bring that Title VII claim because you haven't filed with the EEOC. Well, you've still got a Section 1981 claim, and you've got years before you have to bring that. And again, all things being equal, you'd like to have both claims, but the truth is that the Section 1981 claim is stronger. So you don't, you're probably not any worse off, and you may be just in the same spot, at least legally, if you just bring the 1981 claim. And again, you've got years to bring that. So you could take 3 months to kind of put the pieces back together, find a new job, work in that job for an entire year, and then come back and bring your claim. So keep in mind that the timing in these cases is important, and in many instances, you have more time than you think you do, or you might initially suspect that you do, and you want to use that time to your advantage to be able to put your pieces, put the things in place that you need to have in place in order to put your best foot forward if you decide that you want to bring a claim. So don't feel like, and I get it, everybody's in the heat of the moment. You don't do employment law. You're not reading employment law. You're an expert in something else. We don't expect you to know this, but just keep that in mind. Do your initial research on your own, figure out what you think statute of limitations period are. I think it's well worth talking to an attorney. Either find one of these low-cost resources, or just pay for an hour of somebody's time. If you have to pay $500 to have a sit down with an attorney, I know that can be difficult, particularly if you've just been fired. But it can be time well spent if all you're trying to do is develop a game plan and decide when how much time you have and how you can strategize about how to get your case together. Because after you talk to that lawyer, you should have a good sense of what causes of action you may have, what the timeframes are, and then you can, talk to your family, take some time to think about it, to develop a game plan that works with your time frame, and understand that if it's a matter of, just trying to get your life back together, if it's a matter of saving up money or having an income stream so you can afford legal services, then that is the strategy that is available to you. So remember, talk to your lawyer, figure it out. If you don't have one of those cases where it's a really short time frame, let me just add another wrinkle here. Even if you do, filing with the EEOC, or if you're left the federal sector where you have the 15-day window, bringing something to your EEO officer is not terribly difficult. It can be done without a lawyer. It's often done without a lawyer. Your lawyer can help you, even just for that hour consult, understand kind of the mechanics of doing that. You can touch that base, do the things you need to do, whether it's filing a charge, going to EEO, and then you have even more time after that. But remember, put a pin in it. Keep that in mind. Right after something like this happens, you often don't have to act right away in order to bring your claim, and use the time that you have. So remember, put a pin in it is an arrow in your quiver for being able to handle your case. That's the end of this podcast. I do want to remind folks that we have a website and a newsletter that is called the Career Rocket. I really urge you to sign up for it. It is free. There is a link in the show notes, and there not only you get our latest content on employment law, but you get content to help you bring your career to the next level, whether it's tips on how to negotiate a salary raise, whether it's how to best dust off your resume or develop a LinkedIn profile. We're providing information that really helps you put yourself in charge of a career. Again, it's called the Career Rocket. You can find the website at thecareerrocket.io, or you can find the link in the show notes, and you can sign up for our newsletter, and that will show up in your inbox. And it's free. I think you will find it helpful. And good luck out there. We'll see you next time.